Welcome to Sports Shorts, episode number 76. I'm your host, Bobby Hacker. And my guest today, well, you can't say enough about Gabe Feldman. And as I read his job title, we may run out of time for the whole program. But he's the Shear Garner Professor of Sports Law and the Paul and Abram B. Barron Professor of Law, the Associate Provost for NCAA Compliance, Director of the Sports Law Program and Co-Director of the Tulane Center for Sport, also the editor of our very own Sports Lawyers Journal. Gabe Feldman, welcome.
Thanks, Bobby. I appreciate you having me as guest number 76. I feel honored.
Well, you should be. I mean, you're the one who always teaches on Tuesday when it was a live program. So, not my problem. We've been
I think I
trying.
actually was. I think I was an early guest. I think this is my second appearance.
Oh, well, my records may be, but it's good to have you because there's so much going on that I know you're plugged into and we will get to. But as we always start this program, the first part is if you could give us a brief, as brief as it can be with 17 titles at Tulane, uh, explanation of what your current role is at the university and, the other things you're on, the commissions you may or may not still be involved with, and then talk about what was the path that you took to bring you ultimately to Tulane, where you've been for 20 years? Close?
Not quite 20, but yeah, over a decade. So I run the sports law program at Tulane, and I'm a law professor here at the law school as well. I joined the faculty again in 2005 after I was a litigator for about 6 years at a law firm in Washington, D.C. called Williams and Connolly. And I was practicing about 50% sports law, 50% just civil litigation. And I loved the sports law work, didn't love the civil litigation stuff so much, didn't love the practice of law so much. And I'd started teaching as an adjunct at University of Virginia with a former client by the name of Donald Dell, and then got my own class at Catholic Law School. And I realized that teaching felt fun and practicing law felt like work. So I decided to give a shot to teaching full time. And it was really, I was going to come to Tulane or I was going to continue in private practice because Tulane is one of the only sports law programs in the country and was where I wanted to be and to work with Gary Roberts. And so I started there in July 2005. Something called Hurricane Katrina hit about a month later. I then evacuated with the rest of the city, went back to Washington, and then came back to New Orleans. I've been here ever since. And so my primary job is to run our program, to teach our sports law classes, to help prepare students for jobs in the sports industry. We have a lot of really cool programs here for our sports law students. We have a baseball arbitration competition, a football negotiation competition, a basketball and a soccer negotiation competition. We get about 200 industry executives that come to New Orleans to judge those competitions every year. And we have about 200 teams of law students who participate. So that's a big part of my job is running all of those different programs. I oversee our NCAA compliance office here. So our NCAA compliance reports outside of athletics into the provost office. They report to me to kind of create some checks and balance. So I do a lot of stuff on campus with college athletics. I am still a consultant for the Knight Commission on Intercollegiate Athletics, which is not related to Phil Knight or Bobby Knight. It is an independent group that is designed to focus on reforming college athletics. And it's made up of university presidents, athletic directors, people in the sports industry, executives, former athletes, and I serve as their legal consultant. And I've been doing that since about 2020 or so. It was originally brought on to focus on name, image, and likeness, and now it's expanded a bit because there's so much going on in college sports. But it's been a great opportunity to work with the members of the commission, the other consultants, and also to get to present and meet with lots of folks in the NCAA and in different athletic departments. And as we'll get into, I'm sure in a minute, there's no busier time and more uncertain time in college sports than right now. So it's great to be kind of working with folks and trying to come up with some solutions to the issues they're facing. I also serve as an arbitrator for the Court of Arbitration for Sport and for AAA and for the newly formed USOPC arbitration panel. And then I do some other consulting work and expert work. And I think that sort of covers most of it because I know we only have limited time here. But I think that answered all your questions. I think.
And you have a podcast.
I have a podcast called Sports Wise, a podcast about sports and law. Thank you, Bobby.
Always here to promote everybody's
Yeah,
businesses.
I forgot what I was here to
So
plug. Yeah.
yeah, well, why not? So here we are, and maybe it was a little more than a year ago. General Counsel of the NLRB says basically, well, if given the opportunity, I'd say that these scholarship athletes are employees. Fast forward to the Sports Lawyers Association convention last year, and she was like a Martin Short character when she was like, "I never said that." And now, lo and behold, she filed suit here in my neck of the woods. And on top of that, we have what's going on at Dartmouth. So, what's with the tea leaves? What's happening? Where's college sports going? I mean, how there's some other issues I want to talk about in some other cases, but this one is particularly interesting because talk about opening up a can of crazy. Employees, this is a bridge too far, in my opinion. And where do we go from where do we end up?
So I let me just start with I like the Martin Short SNL reference because it actually makes me feel young because the references I make are so outdated that my students just give me blank stares. But I'm I'm not being defensive. You're the one who's being defensive. For those of you who haven't seen it, you should go watch those sketches. But to your point, it is really interesting when Jennifer Bruzzo, the NLRB general counsel, did write that memo. That was basically an invitation to college athletes to attempt to unionize. And the belief that this board wants to cast as wide a net as possible on who is considered an employee. And we've seen it not only now with college athletes, but other college students and research assistants and teaching assistants. That although in the past they had been determined not to be employees, this board is now seeing them as employees. Why? Because this board, there are three Democrats and one Republican, and they want to have as much collective bargaining, simplifying a little bit, but as much collective bargaining as possible. And one of their targets is college athletes because they feel, again, generalizing, that college athletes have been treated unfairly, that they've been exploited, and that the best way to protect them is to recognize them as employees and give them the right to unionize and then collectively bargain over their compensation and their other terms and conditions of employment. And so we've got the two different paths here. One, as you said, in your neck of the woods, is the unfair labor practice charge that was filed against USC, the Pac-12, whatever we're calling that now, and the NCAA,
The
saying that
Pac
they
2.
have misclassified, the Pac-2, and maybe it'll become the Big Ten as the new defendant, but that they've misclassified college athletes as student athletes when they are really employees, and they're interfering with their right to collectively bargain. And the really interesting thing and significant thing about that USC case, among others, is that the conference and the NCAA are named as well. And why that matters is because the NLRA only applies to private employers, and most of the FBS schools are public schools. And so even if the NLRA applied and college athletes were employees, it would only apply to those private schools. But by including the conference in there and the NCAA and claiming that they are joint employers, so that they are employed not just by the school, but also by the Pac-12 or the Big
Mm-hmm.
Ten, the SEC, that would mean the NLRA applies to all college athletes because every conference is private. So we've got that on one track. And the other track, as you said, the Dartmouth men's basketball players, which if you had asked somebody 20 years ago, will college athletes unionize and who will the first college athlete union be? I think Dartmouth men's basketball would have been about 4,000th on the list, but they filed a petition to be represented by the SEIU, which is a service workers union,
Mm-hmm.
and the National Labor Relations Regional Director in Boston just last week said that under the NLRA, that Dartmouth men's basketball players, even though they don't receive athletic scholarships, even though they don't generate a lot of revenue, even though they are getting an Ivy League education, they are employees because even at Dartmouth, the school exercises so much control over the athletes' daily lives. and that control interferes with their ability to be a student. Because even at Dartmouth, you are not allowed to take certain majors or take certain courses if it will interfere with your practice schedule. And even though they don't generate a lot of revenue, you can be an unprofitable business and still have employees. So you don't have to be making millions of dollars or billions of dollars. You can even be losing money, like Dartmouth basketball claims they are. And part of the factor is whether they're being compensated. And you say you don't have to get an athletic scholarship to receive compensation. The fact that you get preferential admission, that you get apparel and equipment, that's enough to constitute compensation under the NLRA. And if you put those two cases together, if the conferences are joint employers, and if Dartmouth men's basketball players are employees, then it's hard to see how every college athlete wouldn't also be considered an employee, whether you're at D1, D2, or D3. Because again, no offense to Dartmouth men's basketball players, but if they are considered employees, why wouldn't the lacrosse player at Fordham? I don't know if Fordham has a lacrosse team, but why wouldn't the lacrosse team at whatever Division One school? Why wouldn't they be considered employees? They're doing just as much work. They are generating similar amounts of revenue, right? They're both losing money probably. And the schools are exercising significant control over them. So, as you said, this could open the floodgates to every college athlete being recognized as an employee. But the last thing I'll say is we're still at a very early stage. We don't have a decision in USC. We only have the decision of the regional director in Dartmouth. That can be appealed to the full board. That decision can then be appealed to federal court, and then that could ultimately be appealed to the Supreme Court. So we're just at the starting point, but we're certainly further than I think anyone thought we'd be, and with a group of athletes that nobody thought would be sort of leading this drive.
Yeah, one of the concerns that I think may not be taken into consideration, and it's probably not even in the criteria under the NLRA, but if you determine that college athletes are employees, then scholarship athletes are looking at having their value of their scholarship taxed. So if I'm a scholarship athlete at Duke University, for example, where tuition has got to be $50,000 or $60,000 a year,
You can never get into Duke, Bobby. Come on.
well, not me,
Yeah.
but now you're looking at all of a sudden I get a scholarship to go to college, but I'm being taxed on it, and people say, well, you have the right to make money. Am I get is there the delta between my tax liability and how much I can make in NIL? And if I can't make it in NIL, how I mean it's a crazy scenario that really is troubling because oh great, we can organize, we can bargain. Yeah, you can be taxed too. And I think
Yeah.
that's an issue that is not really focused on much.
Yeah, it's an interesting issue. I do think that at least at the FBS level and high level D1 men's and women's basketball, that if the athletes are in a union and they're collectively bargaining, they'll end up better off than they are now. I do think, yeah, they might be taxed on a lot of their income, and maybe the scholarship will be considered income, but I don't know that they will be worse off. I think the bigger concern is what happens to the other sports on campus, and if the cost of football and basketball increases exponentially, are these schools able to continue supporting the Olympic sports and the non-revenue sports and the sports that are losing money? Now, there are minimums that the NCAA has, still Title IX issues, but that we might lose a lot of the broad-based athletic opportunities that we see, and we've already seen schools start to cut because of COVID and for other reasons, and even because of
Sure.
the increased cost of NIL, even though it's not coming directly from the schools. So I do think there's that issue. Whether again the NLRB will care about that and whether that will factor into their analysis, I'm not sure. That might be something that's better directed towards Congress. That Congress will say, look, we need to modify our labor laws so that college athletes aren't looped in here because it's going to be a net negative for college athletes. The, Relying on Congress at this point is not the best idea for anything, but that may ultimately be the best solution if we continue down this path in the courts and the NLRB.
Well, I know that I guess that Senator Booker has, with one of the other senators, has a proposal that's been floating around there. I don't know if there are others, but I mean that's been the issue with NIL in general is You have states that have laws, and then some states don't have laws. And what's the conference? And it's troubling. It's like a crazy conflicts of law question when you get down to it. You know, where do you bury the survivors? You know, it's a unique situation, and having a national framework. As we know, the NC2A was real close. Val Ackerman wrote a great proposal that then, Alston came down, and those efforts were just ended. So I don't know what the future is there, but there's so many changes, and this is my segue into what I think is the scariest of all, which is Hughes versus NCAA. That case, again, and Judge Wilkin, who seems to get every case that involves name, image, and rights, is in her courtroom. This case, now that the class has been certified, I mean, I don't know how long it'll take to they get through this or what the process will be, but looking down the barrel of a potential $4.2 billion liability seems to be a little troubling for college sports overall. Not for
Yeah,
certain lawyers representing the plaintiffs' firm's well-being, but this to me is the scariest of all these cases right now.
yeah, well, and that's why there's an irony here that if the college athletes did unionize and did collectively bargain for restrictions on compensation, then those restrictions would be immune from antitrust law. That's why pro leagues are able to have salary caps and player drafts and all these other restrictions on athlete compensation. But the NCAA, understandably, has fought for so long against employee status that they don't have college athlete unions. And so their restrictions are subject to scrutiny under antitrust law. And with the House case, which is basically saying that every restriction you've had on NIL compensation in the past within the statute of limitations is illegal, and they are looking at and even the current restrictions are illegal to the extent that the NCAA is trying to enforce and crack down on some NIL payments, but they are looking at every NIL deal that is being made now and saying, but for your restrictions, these deals could have happened over the last 6 years. And so those are added to the damages calculation. And as you said, and Jeff Kessler is the attorney bringing this case. He was the one who was the lead attorney, one of the lead attorneys in the Alston case that won in front of the Supreme Court. That $1.4 billion damage number, I asked him about him. He was on my podcast about a month ago, and he said the number is much higher now. That 1.4 billion was before they'd seen lots of developments, and they now have more expert testimony. He wouldn't give me the actual number because it's not public yet, but it sounds like it might be closer to 3 billion. And under antitrust law, what makes it super scary, and by design, is that would be trebled. So you could be looking at up to $9 billion in damages. Now, the class certification has been appealed. There's not been a trial. The NCAA and the conferences and the schools might win that case, but they also might lose. And if you've got a $9 billion award, that could sink the whole enterprise, right? That's
Right.
they don't have the capacity to sustain that, which means we might end up with a settlement. And I don't know what number the plaintiffs would be willing to settle for. I don't know what number the schools would be willing to settle for, but we might end up seeing a settlement of the House case, the Carter case, which is the case that's challenging all restrictions on compensation, and then maybe an agreement to provide certain minimum rights going forward to college athletes. And whether that number is in the billions or the hundreds of millions, I don't know. But you're absolutely right. The antitrust liability that is out there, and there's a new case that's filed every couple of months challenging something else. That is terrifying, just like it was terrifying to the NFL when Jeff Kessler was suing them. And there's more money and fewer schools floating, or fewer teams floating around in the NFL, so they were at least able to potentially sustain the bigger hit. But yeah, it is certainly an existential threat to the future of the NCAA.
Yeah, and what becomes of college sports? Because and when I'm talking about college sports, as you pointed out, there are three income drivers in college sports: football, men's and women's basketball. Any other of the so-called Olympic sports, Very few of those are positive cash flow enterprises, and it's the big sports that generally support all of them. And when you match, all of these sports and the reality of parity, such as it is under Title IX, you're going to be looking at a world where this sort of glorious 19th century idea of interdisciplinary education and arts and athletics and everything else as part of the university experience may exist in a very different way, and it may just be a club sport universe, because how do you afford all these other sports? We've seen with what recently happened with the demise of my beloved Pac-12. I mean, I'm really a Pac-8 guy, but the Pac-12 was that because their inability to get a media deal, a media rights deal, that the basically the conference blew up because the teams had to go to some place where they're going to get the media money, because that income stream is so important, not just to those programs of men's and women's basketball and football, but it's that income, those income streams that really help maintain the 20 to 30 varsity sports that a lot of universities have. So you're looking at a situation where I was asked around the Hughes case about the discussions that, from my days, discussions that were had with regard to rights and how much value we attributed to collegiate athletes' name, image, and likeness rights. And my response was, as multiple people that I've talked with at different networks, was exactly the same, which was, we never factored it into the value of the deal. That was not an issue, because when you're negotiating with somebody and they represent that, you have the rights, we have obtained the rights for the name, image, and likeness of these name, image, and likeness rights of these student athletes, that you get those. So from a network perspective and a media deal, that was never part of the calculus, which makes the argument that the economist and expert that Kessler's using, I got to question where they're coming from, because they're saying, oh, well, the media rights deal included this value, but no one ever discussed the value. It was never even a consideration. But Judge Wilkin, apparently in granting class status, said, sure, we're cool. Let's move ahead.
Yeah, I think their response, the plaintiff's response, would be that nobody discussed the compensation to the athletes because the NCAA didn't allow it, and that they had taken those rights in violation of the athlete's right of publicity and also an antitrust violation. But I hear your point that it wasn't specifically carved out as here's how much you're getting, here's how much we're paying for the athlete rights, because it was all included. But again, I think the plaintiffs would argue that it was illegal that it was all included, that they should have had a right to be paid for it, and that the schools agreeing not to pay them for it should not have been permitted under antitrust law. The other point I just want to touch on that you made earlier, the Pac-12 schools leaving to get that additional revenue, and that additional revenue is necessary to continue funding the Olympic sports. I think half of that is right. They were certainly leaving to get more revenue, but I don't think that USC and UCLA would say that they needed that extra revenue to pay for their lacrosse team. I think they needed that extra revenue because they wanted to continue competing in football and basketball, and that most of the money they're getting is going to go back to football and some to basketball. And look at Texas A&M, where they are paying their former head coach, I think it's $78 million not to
Something like
coach.
that.
Yeah, and then another, what is it, 100 million or to pay their new coach, and they're chasing football wins, and they're chasing that football revenue, and that's okay. But I think if a school is so clearly making a decision based on the revenue they can generate, then you can't be as surprised that a court is going to look at you more like you are an entity that is chasing revenue, as opposed to trying to, as you said, go back to that 19th century ideal of athletics as part of the academic institution. Because I know that the conferences and the schools tried to argue that it was good for the students and their education for the West Coast schools to join the Big Ten and the Big 12 and the SEC. But I don't know that anybody believes that. That's not why they made the decision. It may have some benefits for education, but I think as long as you're putting revenue generation first, then the courts are going to look at you like other profit seeking enterprises. Now, they're not making a profit because the money's going back to the coaches and to athletic directors and to facilities. But I do think there's a little bit of disconnect there that if you want them to treat you like an academic institution that's different than pro sports, you have to act like an academic institution that's different than pro sports. I think lots of schools are doing that. I just think at the very top of the FBS, I'm not sure they are doing that.
Well, it's certainly, I think, an important thing, particularly in public education, the public institutions that have relied so much on state funding for just general operation of the university. And where have they sought to replace that? Well, over time, it seems that media rights deals have funneled a lot of money in,
Yeah.
and there are other ways. I mean, I'm sure if you get half as many requests from Duke to support your undergraduate program, the law school, where everything else, it's changed over the years. I'd get one annual appeal, and now I'm constantly being harangued by the College of Letters and Sciences, the athletic department, on and on and on. It's because their state funding doesn't exist in public institutions anymore. So I
Right.
think there's a lot of moving parts,
Yeah.
and just and you look at universities today, and all this talk about eliminating humanities programs because people don't want those. What are we doing? Are we creating sort of engineering trade schools? Is that in STEM trade schools? Is that what's happening in universities across the country because they want to draw in people that can get an education and get a job? Look, I got an education as a means of going to law school, and I got an education because that's what you did. You learned about the world and you learned about ideas, and maybe it's too provincial an idea modernly, but I'm still all in favor of it.
Yeah, and look, I am very much a fan and supporter of college sports. I love college sports. I love what it does to a university campus. I love what it does for our college athletes. How much people enjoy it. I don't want to see it go away. And but I do think that there is some burden on the university presidents and athletic directors to try to make some changes to make it more sustainable. And I just think it's hard to look at all the spending in FBS football in particular, and then say, well, there's not enough money to spend on athletics because they're spending so much, sinking so much into college football, all chasing the same thing, which is even more money. And it's difficult to control the spending, right? They don't have the protection that the pro leagues do to put a salary cap in. They don't have the ability to limit coaching salaries without being sued. But I do think it's up to all of us that work on university campuses to try to figure out a more sustainable way to have broad based college sports. At least that's what I think. Other people might say, I don't care about the lacrosse team. I just want my college football. Right? And for those people, I don't have a great answer, but I think there is tremendous value in having broad based athletic opportunities, gender equity, um, a chance for everyone to participate, and every school to potentially have a chance to win a championship. That doesn't happen in reality, but we're at least playing on the same field and playing under the same rules. And again, I'd love to see that be as sustainable as possible. I don't think it's sustainable the way we're going now because some court or some governmental agency or some state legislator is going to interfere and just say you can't do what you've been doing. And the question is, and we've been asking this question for a while, is do college sports, do they want to maintain control over the enterprise, or do they want to risk having, whether it's Jeffrey Kessler or somebody else, sue them into oblivion? Or as I think Mike Tyson said, sue them into Bolivia. So I just think it's, that they've got to, either they can stay in the same path and we know where that's headed, which is probably they're going to lose some of these lawsuits and be in trouble, or they can try to change the path and try to get either win some of these lawsuits or get protection from Congress.
So yeah, look, and again, talking about Hughes' decision down the road and the impact it could have, but it's a class. So the amount of money that each class participant would get, even at the mere $4.2 billion number, is a few $1,000s. Okay, so if during that 5 year term I was the starting quarterback at Alabama, or the starting forward at Duke University, or so on and so forth, do I opt out of the class and sue on my own to get more than my $3,500?
Yep. I mean, we
And
could
is
certainly see that, and that's where it's hard. Even if they settle, if they've opted out of the class and opted out of the settlement, you still might see these individual lawsuits go forward. Now, those are really expensive to litigate, and it would take one of the higher profile athletes who could more easily prove those damages. And those higher profile athletes, for the most part, are either going to be playing professionally or have had some success. Now, there's exceptions to that. If you think about Johnny Manziel, if Johnny Manziel wanted to bring an individual lawsuit and say, look at what the other top quarterbacks are making now, and then multiply it by the Manziel factor, because not only was I a top quarterback, I was a brand. And how much would he have been paid to do the money sign? Um, I think Johnny Manziel would be able to make a pretty good case that he lost out on a few $1,000,000. Now, I forget when he graduated and if he would have been in the statute of limitations, but you get the point that
Yeah,
there are
yeah.
individual athletes out there that I think could very easily prove that they lost out on a lot of money because of these NIL rules.
So basically, nothing's going on in college sports. Quiet times. We can focus on other things because the future of college sports looks really rosy.
Look, it gives us a lot to talk about and keeps a lot of people busy. I remember back in 2010, 2011, when the NFL and all the leagues were doing their work stoppages and lockouts, people asked me what I was going to talk about once those work stoppages ended. There's always something. And now it just happens to be college sports.
Yeah, and it's interesting times for those of us that are sports fans. I'm just looking forward to moving forward, having Duke on the Cal basketball team's regular schedule now that we have somehow become a member of the ACC.
Welcome to the
Uh,
Atlantic
I,
Coast. Yeah.
but I just do remember one particular game where Cal played Duke and the good guys
All
actually
right.
won that game.
All
But
right.
that's one.
I
You
was
got
just
about a
listening.
hundred. I'll take one.
I'm reading Grant Hill's memoir, and he talks about that game and how dominant Jason Kidd was. I still remember that. Thank you for bringing that back up.
Well, I mean, going to a new conference and all, and when I got
Yeah,
my call saying you want to renew your season tickets, I said, "Yeah, there's all these teams I've never seen before. I'm
yeah,
I'm happy to
yeah. I
go."
guess there's a bright side. There's a silver lining.
Yeah. Anyway, look, Gabe, thanks for taking the time out to talk with us.
Absolutely.
There's a lot going on in college sports. Obviously, for those of you out there who are not members of the Sports Lawyers Association, all you got to do is go to sportslaw.org and join. And if you haven't renewed, we're on annual renewals, which means your membership expired December 31st. And in another few days, the end of February, all your membership access will be cut off. So renew your membership now and get ready for a great conference we've got scheduled for this May, our annual conference, which will be in Baltimore. And you'll be seeing Gabe there giving us an update, talking about some of the stuff we've talked about, and who knows what else is going to come down the pike in the next few months. And then again, be prepared to hear about our mid-year, our fall symposium, which will be in the beginning of November. More details on that to follow shortly, but that program's coming together as well. So, without further ado, Gabe, thank you very much. I need some more sitting on soccer ball pictures. I haven't seen any in a while. Uh,
Thank you, Bobby. I know that is the only reason people like to stay in touch with me, is to see pictures of my kids sitting on soccer balls. But I'll take it.
all right, guy. Well, thank you very much, Gabe. We'll see you soon, and
All right.
thank you
Thanks,
everybody
Bobby.
for